Judge Lauren Hunt, Julia Thomas, Sandy Ness, and Christopher Ballard for the state.
Your Honor, Scott Williams for Ms. Sundwall, and with me as well is Marissa Barris, special mitigation specialist and my case agent.
Thank you. Counsel, this matter comes before the court as it relates to a couple of different motions, pretrial motions in limine that have been filed. Our jury selection starts next Tuesday. I've had a chance to review the motions. I know one regarding the statements of Kacee Terry wasn't responded to by the defense. Do we have any agreements, or have any of the issues been resolved as it relates to these motions?
I don't think so, but I'm asking the court to allow me to sort of talk through them. I indicated in an email with regard to these legal issues on the two statutes interplay. Worked very hard on, but didn't have time and don't have a written response to those. I'm sorry, that styled as a bench memo anyway.
You're talking about the amended memorandum.
Yeah.
From the state.
I feel like a bench memorandum is exactly to tee up and trigger, to the extent possible, discussions about the application of law and jury instructions coming up. So I'm ready to talk about that. But I did not file a written response to the statements motion, primarily because I think if we talk about it for a minute, my position is going to be almost every single thing that Kacee Terry said is admissible as non-hearsay in this case. And so I can speak to that.
Okay. All right, let's deal with these one at a time. Then I appreciate the efforts that go into these. Let's talk about defendant's motion in limine to exclude evidence of nursing professional standards first.
It sounds like we almost have an agreement on that, and the government's response is we agree, except for that she's a nurse.
Yes, it seems from defendant's motion that Mr. Williams is conceding that the fact that she was a nurse and has specific knowledge about many topics from being a nurse is relevant. The state has outlined what it intends to use, a non-exhaustive list, but along the lines of what it intends to use that knowledge for. The state certainly doesn't intend to make this about, nursing professional standards or talk about what would violate ethics in nursing. But certainly the defendant, knowing what she would have known as a nurse, becomes relevant and probative in many areas that the state has outlined. So it sounds like maybe we are in agreement there, as long as the court is willing to allow us to make those arguments as to her knowledge and how she would have known about certain medical conditions or situations.
Mr. Williams, is that your understanding?
That's my hope. Yeah, I mean, you may recall, even from the preliminary hearing, that I took some cross-examination related issue with the suggestion by some of the state's witnesses that this was morally wrong, or in the nursing profession, it's wrong to do this or not render aid, and et cetera, right? And first of all, I thought I established that absolutely doesn't apply unless it's an actual patient-nurse relationship. Since I think that the witnesses agreed with that, presumably the state does too, that aspect should never be argued. It's not, no witness should be allowed, Dr. Masto should not be allowed to say this isn't how we do it as nurses. This isn't how we act in our profession. Things like that. That's what I'm seeking to exclude.
And it sounds like the state's not taking
And that sounds like they're going to stay away from that. Yeah, she's a nurse goes to interpreting the facts that she knew, and with her knowledge as a nurse. I mean, we got into some of that too, right? These values that Kacee Terry was texting to you of her heart rate and whatever are absurd. That you're a nurse type thing. So that she as a nurse is a nurse with the experience that comes with nursing. that's relevant. Any suggestion that she had a duty, professional duty that she violated, I think should be excluded.
And Judge, just to be very clear, we do intend to elicit statements from witnesses, primarily doctors, about what they would expect a nurse to know. And that might dip into with the information a nurse is seeing, even if she's not acting in capacity as a nurse, like actions that you would expect to be taken just medically, not ethically, not morally, but just what a nurse would know needs to happen medically at any given time. And so I don't want to run afoul of the ruling there, but we do intend to elicit that information, but we certainly won't frame it as she violated ethics in nursing. It just all goes to what her knowledge was and what a nurse, would have known would have been medically appropriate or inaccurate or impossible at whatever stage we're talking about.
Is there a benefit to the limiting instruction?
Well, it sounds like we're close, but we're not on the same page. I don't think that a doctor ought to be able to say, for instance, what would a nurse know? What would a nurse know? What would a nurse know? So given that, what would you do? Or what should the nurse do? That's the motion in limine here. I'm asking that not be allowed. I don't see how it's relevant what Masteller thinks he would do, or a nurse would do, or should have been done, or speaking to what a person, especially a nurse, should do as a nurse. I think that's not relevant. It's not what she should or shouldn't have done. Unless there was a professional standard that the witness could speak to along those lines, they're just emoting on or commenting on something that they need not comment on. And it's highly prejudicial to have a bunch of doctors and standing in judgment of what a nurse should or shouldn't do in a particular situation. And I think the reason is, as we've established, they're talking about patient nurse, right? I mean, this is not the situation. No one's arguing that this was a patient nurse, I don't think, relationship. So why is it relevant what any of these people would do or think she should do as professionals? And was it relevant? That's my point. And I think it's highly prejudicial to have a bunch of doctors stand in judgment of her as a nurse when she's not acting in a nursing position, and they're not here to testify as experts on that subject.
Judge, if I may give,
Please.
I think what will be a helpful example of how this might play out. And this came out of the preliminary hearing. A number of vitals were communicated to the defendant from Kacee Terry. Those vitals, many of them are medically either impossible or highly implausible, given what she also said. She's claiming to still be alive and moving around and talking, but having these vitals that a nurse certainly would know is not consistent with life or the condition that she's purporting to be in. So for instance, if I were to ask one of the witnesses, a doctor, like, would you expect a nurse to understand what these vitals mean? Yes, I would expect a nurse to understand them. And what medically might they mean? Well, these vitals would signal a medical crisis. And whether or not morally she should have acted upon that, she would have known that means there's a medical crisis happening. And her knowledge about, whether the victim was in medical crisis, particularly on the 12th, is very probative and relevant, because we do have evidence that the blood sugar was being monitored by defendant. And as that level continued to drop, her knowledge of what those numbers mean, what they mean for the state of the victim, and what they mean in terms of is this a medical emergency or not, is highly probative, and it goes directly to the elements of the case. It goes to causation. It goes It goes to all of that, her mental state at the time and what she knew and what she did with that knowledge.
In a way, it still gets to what the professional standards are of a nurse, though, too.
We're not going to couch it as, she was a treating nurse. She's an unethical nurse, but somebody with a nurse's knowledge would know what these vitals mean. And if they are, in fact, if they believe that they're true, they would know that this is a medical emergency.
Mr. Williams?
A couple of things, Your Honor. In that regard, on the day of and the glucose monitoring and things like that, anyone would know what they mean. Mark Farnsworth would know what they mean more than any doctor who's coming to this trial, the poor guy, his history with diabetes and insulin and everything else. So why is it important that a nurse would know? By the way, it's interesting because, in fact, the evidence is that she did a search right in the middle of the day, she being Meggan, of what the readings mean on this glucometer. So it's a search about what the glucometer levels mean. But I mean, the blood sugar is going low, and then it goes to unconsciousness. You're just sort of adding a layer with the nurse that's not relevantly probative, but is prejudicial because it suggests a greater level of, a higher standard of what should or shouldn't have been done. If you're asking a doctor, here's the text, these are the vitals that got, now let's move out of that day, because the other evidence that we dealt with, the prelim was, I think I took it as sort of mocking the notion that a nurse would believe the vitals. That's a different aspect of the case, right? I don't know what it means to the prosecution, but on such and such, I mean, if these were the vitals, would a nurse know that those couldn't possibly be consistent with someone being conscious to text them? And I agreed with, well, on cross-examination, I pointed out they're just so foolishly and obviously not possible that a nurse would know. Anyone would know, but a nurse would know. Okay, fine. But then it shouldn't be, so what should she do? In the example,
Then we're getting into professional standards.
right, I don't think that but then what should she do gets into it. That an engineer sees something happening, and let's give you probably have it in a civil case. Some engineer didn't do something right. And because he's an engineer, he should know more than just the guy walking down the street that there was a structural problem. Okay. That's probably relevant that he has a background that would give him that knowledge. Meggan Sundwall, that she has a background in nursing can give her the knowledge that about some things that the layperson wouldn't know. But moving to the next step of, I mean, why medical crisis? Why does that matter? And then certainly the next step, what would you do, doctor, is just not appropriate in my position. Respectfully, that's my position, is we're getting into areas that are just prejudicial, that are judgmental of what she should do and don't apply probatively to the issues in our case, but are therefore just not relevant or more prejudicial to get into. I'm sorry if that was rambling, and if you have any questions,
you're just
interrupt me.
Ms. Hunt, anything else?
Yeah, Judge, if I may, part of the state's causation theory here is that the amount of time that was allowed to lapse without medical intervention, which the experts will testify that's how insulin ultimately ends up killing you, is it can be treated if treated promptly, but the amount of time left untreated is part of that ultimate causation of death. And it's highly probative that the defendant is a nurse, was monitoring those levels throughout the day. And whether professionally as a nurse, she, should have stepped in, she certainly had knowledge of what that was leading to. And whatever steps she took or failed to take at that time go right to her state of mind and to causation. Those go to the heart of the elements of the case. And I think any prejudicial value of she's an unethical nurse or violated nursing standards is not unduly prejudicial under Rule 403. I think here the probative nature of this evidence outweighs any danger of undue prejudice, because they're going to know that she's a nurse. Obviously, the state is presenting evidence that what we believe supports she murdered somebody, and so whether she acted in accordance with the professional standards of nursing, to me, it's not unduly prejudicial given the evidence and the accusation, the charges that the state has already leveled against her. So, but what is highly probative and relevant is her knowledge of those things. And I don't intend to ask any of the doctors, what would you do? But certainly, would you expect a nurse to know this? And are these vitals, would that be considered a medical crisis? Yes, because a layperson might not. I guess it might seem obvious to Mr. Williams, but I don't know that juries are terribly familiar with vitals or what a nurse knows. But Meggan certainly pretended for a very long period of time that she did not know that those were medical crises, and she was acting as if those numbers that were being reported to her were consistent with what Kacee was describing. And the state's ability to highlight that disconnect goes right to her knowledge, her intent, and causation here.
And that's kind of so the issues are blended in a way. That's why I asked about the benefit of a limiting instruction. I know the state's proposed one that might help. I know that then the state's agreed that they're not going to present any evidence that, correct me if I'm wrong, Ms. Hunt, that Ms. Sundwall violated her professional standards as a nurse.
No, we're not going to get into what those standards are or duty or anything like that. We're not asserting that she was acting as a treating nurse at the time, but her knowledge of what's going on is highly probative.
Okay.
Could I address something that,
of course,
I think is actually new from what I just heard from Ms. Hunt and needs to be addressed? Because we might as well figure it out ahead of time, and it applies to my argument on probative versus prejudicial. Not that the state should be barred from making any argument that she caused the death here by not acting. And that's what I think I just heard. Failure to render aid is specifically noted, at least in the lesser included statute we're about to deal with, as something that is not criminal. So if there's to say a nurse would know she's dying and she murdered her by not doing anything about it, we better spare that legal question out, because I don't think they can argue that. They can't say this is a murder because she didn't do anything about a dying person. And then you really get at the problem of the nurse, right?
And sorry, Judge, if I may, I can clarify.
please.
We're not intending to argue omission or failure to act or failure to render aid in that way. But causation, I mean, the evidence supports a number of affirmative acts that Ms. Sundwall took on that day that prolonged the amount of time before medical aid was able to be rendered. And so it will be framed as affirmative acts that she did. We're not relying on omissions or a failure to act, but that is legally permissible causation.
Yeah, I respectfully at this point disagree. I will say I'm just sort of, we're hearing about it now, and I don't fault the state for that at this point in time, but if we do well to work on this notion, because I don't think they can, for instance, in this context. So what if you held the door closed, then you murdered him? where are we going to get with that? Now, we have a very, as you already know, the overwhelming theme here is a suicide circumstances. I know the state will present a case that she wasn't committing suicide or attempting to commit suicide, and that's their position. Of course, it has to be. But I think we have some tricky things to figure out on causation if quasi failure or, well, I already gave an example. Is someone now a murderer if they held the door closed? I don't know. Maybe that's the theory. Maybe they are, but I haven't thought through it that way, because if those sort of ancillary acts are going to be the causation argument, I think that they're slippery slope into failure to render aid. And it's going to make for some tricky rulings insofar as if you agreed, then evidence might be more probative than if you didn't agree that they can take that theory. That's my comment.
Thank you. Let's move on to anything else on that motion.
Unless you have further questions.
I
No.
don't, not right now. On the state's motion in limine regarding certain statements from Kacee Terry, do we have an agreement on that then?
It sounds like Mr. Williams may not be objecting to any of those statements coming in, if I understood him correctly.
Yeah, I see this case involving an extraordinary amount of statements made by Kacee Terry that in many cases would make it very difficult to get through, because they would tend to be hearsay. Except for, first of all, obviously she's not available as the witness. Second of all, our position, we'll take it right now, is that nothing she ever said as ever for the truth of the matter asserted. We don't think anything she said was ever true. So they won't be they will only be in relation to the effect it had on the listener, or information for our expert about personality traits, examples. So with each person in this case, in her family, for instance, she lied about what the other family member did or said or felt. She'll tell her ex-husband that her family hates her. She'll tell her family that her ex-husband hates her and won't support her. She'll tell one person that her daughter died. She never had a daughter. You know, these sorts of, the prevalence is relevant in a variety of ways to understanding the relation dynamic that we have Dr. Hancock coming to testify about, and also what people did next or didn't do next, and what Mark Farnsworth did in reliance on the information. Those are all things Kacee Terry said, and we think that almost anything she said can come in if it's not offered for the truth of the matter asserted, as you're saying.
Is it worth considering a limiting instruction that the jury can't consider Kacee's statement for the truth, for why the sister acted the way she did that night?
I mean, we can talk about that. It is a remarkable case, though, insofar as you understand our position, is that it's all about what people did in relation to lies. So and they'll get it. I mean, the jury's going to understand that that's the point. But if we want to give
ball's
them,
going to be in your court on that issue, more or less, I guess.
Okay. Yeah, I mean,
as it comes up. So it's,
yeah. Okay. Well, sometimes we do. We have, as you know, very commonly an instruction about, you may have heard statements made by others. They're not to be considered for the truth of them. They were offered in evidence to. Well, you have it. We have it.
and that's something for you and Ms. Sundwall to think about, talk about as we get into this,
Right.
and as we move along. But it's going to be up to you.
Can I just ask a clarifying question? So the state's I guess fear or worry here was that these particular statements made to various people throughout the years that Kacee believed Meggan was trying to kill her might violate 403. They might be unfairly prejudicial to the defendant. And so if Mr. Williams wants everything in that Kacee said, and that's part of his strategy to highlight that much of what she was saying was lies and different to different people, that's, I think, permissible. I just want to make sure from the state's end that we're not eliciting anything that is going to be in violation of Rule 403. So I want a record of that. If that's part of Mr. Williams' strategy, then I agree. I think we can freely talk about what Kacee told different people. But
That's how I understand it, Mr. Williams. Is that your
Yeah, right.
position?
And
Okay.
it's their argument. That's why I didn't respond to the motion. I'm sorry.
Okay. No,
And also time. and
you
other
were just fine.
things. But it was because as I was thinking about the case, sure, they're right, because it can't be offered for the truth of the matter asserted. Kacee Terry didn't mean anything truthfully, including this is our position, right? So we can't take that position and then say it should be excluded. Since we think it was a false statement, it's not hearsay. And I don't know that I mean, I guess 403 needs to be applied all through a trial, and I think the parties will be anticipating coming to the bench and making sure that if it could trigger a 403 issue, any particular statement that we vetted
We can deal
before
with
we
that.
blurt it out.
And I would
It's be
appreciate
tricky.
it. I would appreciate coming to the bench with the jury present on those issues.
Yeah.
I'm talking with pros. You guys know how it works.
Yeah, I think the 403 stuff is gonna pop up in this, maybe with some of these statements too, but I think hopefully we'll be in, if we anticipate that's coming, then we can address the court before we seek to admit them.
Okay.
I guess our position was we don't intend to elicit those statements from any witness other than Kylie. But it might be tricky to, I mean, certain witnesses kind of tend to offer that information, and we want to know how careful we need to be about having them not say anything related to
That's where
that.
Mr. Williams can jump right up and we'll deal with it.
Okay.
Yeah, I think we'll need to work through that. I mean,
Yeah, I think
I mean,
that
we've got-
any trial you have dealing with 403,
and this one's
you're gonna,
especially tricky because if it's just this hearsay feature of the lack of not offered for the truth of the matter is just replete as it goes to Casee's statements. And I think it makes other statements, once we start introducing one, we need for completeness, rule of completeness and other things, other would-be hearsay statements to put it in context, right? So sure, Mark Farnsworth says Kacee accused him of wanting to steal her life insurance policy, where she tells someone else, Kylie is trying to steal my life insurance policy, and then tells Kylie, Megan's trying to kill me, and then tells Megan, Kylie's ostracizing me. It's all going to be necessary to get a full and complete picture of what these statements really mean in our position, don't we?
and we can deal with them on a case by case
So
as it comes up.
I'm sorry, I guess for the record, I guess the state's position is we are withdrawing that concession then to not try to elicit those statements from other witnesses other than Kylie.
Mr. Williams?
Yeah, I would like to work on it as we go through the trial, applying the rules of evidence.
Okay.
These particular statements.
I think we're on the same page as it relates to the states then.
Okay.
Motion limited regarding certain statements
Thank you.
of Kacee Terry. Every trial has a lot of nuance to it, and this one in particular does. We're gonna have to deal with them as they deal with those issues as they come up.
Yeah.
Let's talk about the state's memo on interplay between murder and aiding suicide. There wasn't a request for relief from the state, but I can see where we're kind of going here. So I'm interested in everybody's thoughts. Who wants to talk about that? And Mr. Williams, you're prepared to talk about it this morning too.
I am. I've done everything. We've actually had some discussion while Ms. Sundwall was getting dressed. I think it's extraordinarily pithy and complex in a way. And because of that, I wish I was smarter. I'm going to do my best on the subject. But yes, I've been thinking about it for a week and researching.
And is this one of these issues that also we're going to need to deal with in the moment based upon what has come in and what's been received. And then I have to decide
I don't,
whether there's a rational basis.
I don't think so.
to-
I mean, I can't imagine, I mean, I can't imagine that, I think the state's conceding that almost certainly the state of the evidence in this trial will be such that if the defendant seeks a lesser included instruction for aiding suicide, that it should be given. It's trying to deal with how that, if it occurs, how to manage that in connection with the murder statute because it's charged, because what my position is, it's this terribly written and poorly conceived aiding statute, the way they put it in the manslaughter code, and it's never been applied. You get to do it the first time ever, and you'll be doing it the last time ever too, because they got rid of it. And effective May, they've moved all this stuff into subsection statute 211. It's going to be, and making it so grunt.
It's House Bill.
So are you arguing that the state needs to put on additional evidence as it relates to that outside of the count charge?
I think the problem I have here, and I've talked to like appellate attorneys because I want to make sure I'm doing a job with a record as well, right? What is this is what we're about to talk about. What is this? And most importantly, in relation to a murder, because is it an affirmative defense? The state argues no, and I understand it. We've talked about that. I don't really think our analysis is ultimately that different legally, but except where I think I do need to argue each of the following things. First of all, that regardless of the argument, and I'll let the state make it because Mr. Ballard will make it better and describe things better. But regardless of the argument that it doesn't say it's an affirmative defense, and the legislature, according to law, makes affirmative defenses and articulates them, and it doesn't say it is, my position is going to be they have written this up so it functionally has to be. And then, of course, that triggers is burdens change. If it's an affirmative defense, the government has to disprove it beyond a reasonable doubt. Second feature that I would argue in alternative is that it needs to be treated, presented, proven, and argued and instructed as a mitigation, sort of like special mitigation, which is in the same code provision as we're dealing with the aiding statute, right? So if we're doing manslaughter, maybe if it's okay with the court, I'll call it a 205, and it's 205B2, or is it 2B? 205-2B is our aiding. The point that I'm trying to get to, and I will talk about, is C is special mitigation. Subsection C, the very next thing under it. I'm sorry, that's not right, is it?
It's 2C, I believe.
Yeah,
That's not special mitigation.
not-
That's
that-
imperfect
that's
self-defense.
right. That's imperfect. So that, and we'll get to that. So the point being is, does this functionally act? The legislature did not say the things that they should say if this was going to be an affirmative defense. They didn't. So that state's position is, so it's not. And I get it, except for we talk it through and try to, especially on the facts of this case, it becomes extraordinarily tricky because, yeah, this is going to be all about the claim that this was a suicide or attempted suicide. I mean, that's what everyone believed. I can play you clips from the first month where Mark Farnsworth believes that the minute the cops show up, that the police repeatedly utter that. They tell my client that at worst, that it looks like she may be in trouble for a manslaughter. Mark describes less than 2 weeks after the event, how it not only could have been a suicide, but it looked like there might have been a backup plan that Kacee had to abort the suicide attempt, or a fake. We've talked about that too. This could have all been a faux suicide. And That's interesting, right? Because let's get back to the statute. It cannot be the case that the alleged aider needs to know, and unfortunately the word's knowledge, with knowledge that the person's committing or attempting to commit suicide, because that can never be known. When we do these things, look at imperfect self-defense, reasonably believed. It all has to be the objective position of the actor, Meggan Sundwall. And I have some crazy and fun hypotheticals that show. I mean, what if it was a fake? And they charged it. Would I have the defense that no, my client committed murder? She didn't believe. It wasn't. Our position is that they haven't proven that it was a suicide attempt. So if you think my client caused it, it's murder, and they didn't charge that. Of course, that's absurd. But you can see where it logically flows from the friction where both of these might apply, which I think they will. This is an aiding case in our position. Of course, it's an aiding case. And the only question is, did the aid happen? So we're going to be in this dynamic. What does the state have to show? Because you have this awkward situation that they don't want to argue what was a suicide under that element. If you give the elements instruction, because we have a lesser, of course, they don't want to argue that the evidence shows that. They want to argue it wasn't suicide. So, and then when we get to Meggan Sundwall's mens rea on the question of suicide or attempted, what is it? It can't be knowledge, even though they wrote that in the statute. And is it then reasonably believed? Okay, and I'll turn it over to the state, unless you have some questions that help tee up the state answering.
I don't right now.
Okay, but you see where I'm going with this.
I think I do.
Okay.
Mr. Ballard, I'm sorry. I asked Mr. Williams the question first to get his position to make sure I was kind of having. I thought I knew where this was going. I still think I do. What would you like me to know?
Thank you, Your Honor. Christopher Ballard on behalf of the state. Let me just give you some clarity as to what we are seeking with this this issue that we've raised. And the clarity that we're seeking for is what is the state's burden? What's the state's burden of proof depending on what is at issue at trial? We know aggravated murder is at issue. We know the state bears the full burden of proving aggravated murder. Now, if the defense requests a lesser included instruction on aiding suicide, we believe that that's a lesser included offense, and that would not change the state's burden in any way on aggravated murder. The only thing that changes the state's burden, or the only things that do, are affirmative defenses. And the legislature has not made aiding suicide an affirmative defense. And we've referenced the State versus Drej, D-R-E-J case. I've got a copy of that for Your Honor if you'd like it.
I've reviewed it.
Okay, great. Because I think that's critical. And when I bring that up, I want to first mention Drej is very, very helpful in figuring out what is an affirmative defense and when the state's burden becomes more onerous, when the state has an additional burden to disprove something. But Drej is not about lesser included offenses. It doesn't talk about burdens with respect to lesser included offenses. So what we want to get clarified is if at trial this court finds that if defendant requests an instruction on aiding suicide as a lesser included offense, and this court finds that the evidence supports that, then the state would not have any additional burden to disprove it, because that's not an affirmative defense. If And then also, if special mitigation becomes an issue under the special mitigation statute, we think it's clear that the state bears no burden to prove special mitigation under 76.205.5. The case law is clear that with special mitigation, if defendant's going to try and argue that the state's burden, the defendant bears the burden to prove special mitigation by a preponderance of the evidence. We don't think that special mitigation could apply here at all. Now, defense, I think, is kind of commingling these issues of special mitigation with respect to the statutory, I was going to say defense, it's not a defense, but the statutory provision of special mitigation. Defense is commingling that concept with mitigation in general. Now, lesser included offenses mitigate a defendant's guilt for a greater offense. And so we would agree that in that more general concept, aiding suicide would be a mitigating defense in the sense that it's a lesser included offense. But it's not an affirmative defense. It's only a lesser included. And it certainly isn't special mitigation. So let me just explain why we don't believe it's an affirmative defense. Under Dre, you get an affirmative defense. Something becomes an affirmative defense if either the legislature explicitly states that this is an affirmative defense, like the legislature has done with imperfect self-defense. If you look at the ag murder statute or the regular murder statute, it explicitly includes imperfect self-defense as a lesser included offense, or excuse me, as as an affirmative defense. Thank you. You can also have an affirmative defense if the elements of the defense negate an element of the charge, the greater crime. We don't believe that that's the case here, because these are clearly separate crimes with separate elements. If you provide aid to someone to help them, let me back up. To commit aggravated murder, which is the state's case, you have to intentionally or knowingly cause the death of another with an aggravating circumstance. Those are the elements. None of the elements of aiding suicide negate those elements. They might mitigate, but they don't negate or completely cancel them out. The analogy would be with perfect self-defense. Perfect self-defense is an affirmative defense because it negates the criminal liability for intentionally causing a death. And so therefore, if perfect self-defense were at issue here, the state would have to shoulder the additional burden of not only proving aggravated murder, but then disproving perfect self-defense. But aiding suicide doesn't negate any of those elements. They're additional and separate elements from aggravated murder. And so that's why we believe, so not only has the legislature not designated it as an affirmative defense, it doesn't negate any of those elements. And so therefore, at best, it's a lesser included offense that defendant might be entitled to. And if the jury believed that that's truly what happened here, then the defendant would be entitled to that mitigation in the general sense. But it's not an affirmative defense that requires the court to specifically instruct the jury that the state has to disprove any particular element. And really, I think when it comes to instructing the jury, there's two different burdens, I guess you could think about. You have the state's legal burden to disprove certain things or to prove certain things, and then the state has a practical burden of proof if it's going to prevail on its case. With if you have a situation, say with aggravated murder and an affirmative defense, a true affirmative defense of perfect self-defense, then the state has the legal burden to, as I've explained, disprove affirmative self-defense. When you just have a lesser included offense that's not an affirmative defense, the state doesn't have any additional legal burden, but it would have a practical burden to try and disprove that offense. But the fact that the state has to then argue to the jury, this was not aiding suicide, this was aggravated murder. That's just the practical burden the state bears. It's not a legal burden for the court to instruct the jury that the state now has to disprove the elements of aiding suicide. Does that make sense?
I think so.
Okay,
Thank you.
you're welcome.
Mr. Williams?
In relation to Dredge. So Dredge, of course, as you know, was dealing with special mitigation in particular, specifically grappling with the notion of who would have to prove something. Is there burden shifting involved? Is that due process problem, et cetera? And the reason that Dredge speaks to affirmative defenses on the issue of affirmative defenses is because the argument of Dredge, if I've got this right, as I understand it, the argument was on appeal that it should be treated like an affirmative defense. Special mitigation should be. And therefore, the burden should be for the state to have to disprove it. That was the nature of the issue. So the court spoke about affirmative defenses in trying to differentiate special mitigation from one. But I don't disagree, even if it's technically dicta, I guess, that the principle is that the legislature has the authority to designate affirmative defenses. I think when you practically deal with this this aiding statute in this circumstance, they have done it. Whether they put the label on it or put it in the right place, they've effectively made a situation where it is an affirmative defense. And here's the reason. I think that it's a little bit too strict and technical to say that the aiding statute does not eliminate or negate an element of the homicide statute. Because it does, in a way, right? And first of all, it clearly mitigates, and Mr. Ballard acknowledged that, it would mitigate the crime. And the only reason is because there would be a suicide or attempted suicide involved. That's the only reason. It negates, if that finding were to be true, and we haven't gotten to the problem that they didn't use, that the actor reasonably believes in the suicide. But let's just stick with this idea in a strict sense of my argument, which is they created one. Either they screwed up and created it, or they meant to and did think it through and put it in the right section, which I think our present legislature realizes. But the attempting suicide would negate the gravamen, would mitigate the gravamen of the offense, right? It would mitigate the otherwise murder. That's the only difference. That's not fair. It's not the only difference, because there's this notion of aid, and what does that mean as it goes to causation? That's not spelled out either, right? Let's say they just charged us in the first instance and we were only dealing with this. This doesn't give us great guidance on causality all of a sudden, right? As soon as somebody's involved in an attempted suicide and the aiding actor reasonably believes and intentionally aids, doesn't speak to whether or not that needs to be proximate cause. And the law generally doesn't require that the actor's involvement in what ends up being death be the only cause anyway, right? In murder cases even. So if we treat the aiding as the actus reus, the only thing that is different is if the person who died is reasonably believed to have been involved in attempted suicide. That's the only difference. And the only thing it goes to is the gravamen. It simply is not the case that if somebody is engaged in it and you do something to aid, that it could be a murder. They wrote the law. They put it in there. And so how could it creates an impossible dialectic as simply, if it's simply treated as a lesser in the normal course of the way lessers are presented. And I agree that it's frustrating and intractable in terms of some of this legal reasoning. It's never been charged. We don't have any case law to help us. We don't have any legislative history to help us. And never was there a case where it's going to be more pithy than this one. This theory of this case is for us is a suicide. So it's like self-defense where you don't need much to get to that jury instruction, that dynamic. We don't need anything here. This is going to be the issue of the case. What are they going to do back there? Who has to prove that lesser? Well, the government's saying it wasn't suicide. What does the defense have to prove it was suicide? I would argue now we're in burden shifting problems all over the place, just like the ones that Dredge was concerned about on Dredge's appeal.
That there are going to be facts elicited from multiple witnesses talking about suicide.
Absolutely.
Or statements made about wanting to commit suicide.
Replete. Well, there'll be, we believe, we will take the position there's overwhelming evidence in support of it beyond even the discussion the night before that that's what was going to be done, is a suicide where she would be present. They described it. There's a roadmap that within 24 hours. Now, I think the state's theory, it must be that notwithstanding that, it just wasn't a suicide or wasn't an attempted suicide that happened in there. But it goes to the burden of proof. If we have that lesser in, the state's like, we don't need to prove it's a suicide. Normally, they still need to prove the elements of a lesser. They still have the burden to prove those. And they don't. Their argument is, it wasn't. We can't be left to prove it. So the only way it practically works is an affirmative defense. It's just the only way it works. And if I'm right, and or if that analysis is right or agreed upon by your honor, ultimately, then we have, if that were your ruling that it acts as an affirmative defense, I think we probably won't have much disagreement about how it needs to be instructed because we know how to instruct affirmative defenses. Did it 4 weeks ago. So, we know how to do that. I don't know what we're going to do here if my analysis is incorrect. So that's why we're pressing this notion. It's just functionally, in this case especially, it doesn't make sense. It's unmanageable if it's not under the rubric of affirmative defense. Do you have any questions as I stand?
I don't. Mr. Ballard?
Yeah, Your Honor, if you look at the Dre case, it talks about this functional test that the defense is trying to rely on. If you look specifically at paragraph 15 and then also at paragraph 20. First of all, let me just quote this first sentence in paragraph 15. The legislature may assign the burden of proof for an affirmative defense to a defendant, so long as the defense does not negate an element of the offense. So under the federal Constitution, even if this were an affirmative defense, as long as it did not negate an element of the defense, the legislature could decide to make defendant prove it. Utah has a different rule than the federal Constitution. Anything in Utah that's an affirmative defense, the state has the burden to disprove. But then when you go over to paragraph 20 in Dre, it talks about this functional analysis. How do we, where the legislature hasn't specifically labeled something as an affirmative defense, how do we know when it becomes functionally an affirmative defense? And if you look further down in that paragraph, there, the legislature in Dre is focused on special mitigation and the elements of special mitigation. And they note, the elements of special mitigation do not contravene or rebut any of the statutory elements of murder. That's why under the functional analysis, it's not an affirmative defense. And we have the same situation here. Aiding suicide is mitigating. It's a lesser offense. It's manslaughter, but it doesn't negate, contravene, or rebut any element of aggravated murder. Let's take a different scenario than this case with a lesser included that is not an affirmative defense. Let's say the state had charged depraved indifference murder. The defendant, if the evidence supported it, could be entitled to a lesser included offense instruction on reckless manslaughter. But for the state to be able to prove its case of depraved indifference murder, you wouldn't instruct the jury, and to find defendant guilty of depraved indifference murder, you also have to find that the state has shown beyond a reasonable doubt that the defendant did not act recklessly. That's already inherent in the state's burden to prove the mental state of depraved indifference. So I tried to find a case that talks about what is the state's burden of proof when you have a lesser included that's not an affirmative defense. And I couldn't find one that specifically talked about that. We've cited the cases that we feel like are most appropriate. I think practically what defendant is trying to say, it has to function as an affirmative defense. But that's not the case. Not every lesser included is also an affirmative defense. It's only an affirmative defense if the legislature labels it or if it functionally works under the test that we've talked about. If you look at State versus Powell, that's the Utah Supreme Court case from 2007, where it talks about generally the theory behind lesser included offenses and the reason that we give those instructions. The Supreme Court explained that the reason defendants can get lesser included instructions that are not affirmative defenses is because it gives defendants the full benefit of the reasonable doubt standard and a less dramatic alternative than the choice between conviction of the offense charged and an acquittal. That's the way lesser includeds work. And if the evidence creates a reasonable probability of an acquittal on the greater and a conviction on the lesser, the defendant's entitled to that. But it does not then become the state's burden to legally have to disprove the lesser and have the jury instructed that it specifically has to disprove those elements. It's the disproof of those, the functional disproof of the elements of the lesser comes in the state's burden to prove the greater offense. And then defendant has brought up a few times, I don't know that this is really relevant to this discussion, but defendants brought up the new, the bill that the legislature is considering right now. It has not passed. As far as I can tell, it's on the third reading calendar in the Senate. I think if it passes there in the next few days, it will pass. But this is House Bill 221. House Bill 221 creates a new crime of aiding or encouraging suicide. And it basically takes what's currently in the manslaughter statute now, puts it in its own section. But none of that would apply to this case because the law that applies is the law that was in effect when these actions occurred. And it especially doesn't apply because it doesn't change the level of offense. It still remains a second-degree felony, whether it's under the statute as it existed at the time or under this new statute. What the new statute does is take the existing crime of aiding suicide and adds to it. You also, not only do you aid, you also encourage, and there's additional elements there. But I don't think the court needs to worry at all about the new legislation. Do you have any further questions?
I agree.
Yeah, I mean, I didn't bring it up for that reason. I'm not an appellate lawyer, so I'll defer to you all, but I mean, maybe I should make the record and urge that it's relevant insofar as it's indicative that the legislature thinks they weren't clear enough. But we're back to this as it sits in our lap with the existing statute right now. And paragraph 20 says it all, right?
Right.
It says you have to look at how it functionally lives in the case. They don't have to say it's an affirmative defense. They have the authority to do it, but they can't get around it by intent or by mistake. I don't know what they meant, but it negates the gravamen and severity by a feature of suicide. And I think functionally, that's my argument. I mean, it's exactly 20. They lost there because that was a designated special mitigation, right? That was a statute, and they did a functional test on it and said it doesn't functionally work as one. I'm saying when we do that same test here, I don't know how to get around
If it's not a functional affirmative defense and the state doesn't have a burden, it doesn't look like there's any dispute that we could still include you could still ask for a lesser included offense. Is that right?
it.
Just
Yeah,
in the simplest terms that I can think of right now.
that's why
Yes.
we're here.
That's still an option. and a
Defendants,
possibility.
the defense could certainly ask for that. Yes.
Okay.
The reason we bring this issue up is that if that happens, we don't believe that increases the state's burden in any way.
I think that's probably the rub, does this get treated as a functional circumstance with it's functioning as an affirmative? Then again, I expect the state would disagree with that ruling, but if you made it, we probably would know how to instruct it. It would get instructed like affirmative defenses get instructed with the burden of the state having to disprove the suicide attempt.
I'll tell you, all of you right now, I got this amended memo yesterday. Didn't necessarily have time to do it, but I did spend a lot of time going over that. And so I was really interested. I kind of had an idea where Mr. Williams is going to come from on this. And I go back and forth. This is more nuanced than a lot of issues that we see on a daily basis. I'm not going to have a ruling ready today. It's not it was a memorandum cloaked in the form of a motion, more or less.
Sort of a
I
declarative
Declaratory judgment.
declaratory
and
judgment.
I
We'd all like to know ahead of time.
and I can see that. I'm not going to have a ruling on this today. When I do, I want to be very clear for the record as to why.
And the state appreciates that, Your Honor. I think we anticipated this issue coming up and recognized, as Mr. Williams would say, it's pithy, or as Your Honor would say, it's very nuanced. And we didn't want this to be an issue that Your Honor had to deal with in the middle of trial.
We're going to have enough of those anyway.
Yeah.
Every trial has them. What we may
Right.
not. We may not. But
We're trying to
every
avoid
trial.
as many of those as possible, and so that's why we raised it when we did and how we did. We apologize that we didn't give Your Honor even more
No.
time to think about it.
No, I'm anything that we can handle beforehand is helpful.
One of the reasons is because we commonly talk about burdens in opening.
And the parties are you're gonna have your witnesses ready anyway. You're gonna know your cases. Whatever
No, I mean,
whenever I come back with this, you're gonna be ready to adjust and everything.
yeah. I just don't know if you contemplate giving us at least guidance before opening.
Oh,
Because-
certainly.
Okay, yeah, because both
Certainly,
parties
yes.
talk about
No.
burdens and openings.
No, certainly. We can. We may have to wait until we get the jury selected, and then we can send them home, and then we'll deal with all these issues then too. No, you certainly are going to know where I'm coming from before you make your opening statements.
Your Honor, that statement makes the state nervous because we believe
I get it.
we believe that this is a foundational principle or a foundational element of this trial. And that if Your Honor rules against us on this point, we think this is important enough that we'd seek an interlocutory appeal on this issue.
I understand.
And we don't want to seat a jury and have jeopardy attach and proceed under a burden that we don't believe we should have to bear.
I get it. I'll have an answer to you before we seat a jury. We're going to know one way or another.
Thanks, Your Honor. And I'm not trying to throw down the gauntlet. I'm just saying that's how
we'll figure it out.
see this.
We will.
Yeah,
I'm gonna take a short recess. We'll come back and talk about defendant's motion in limine regarding nursing professional standards. I'll be back in just a minute. Anything else we need to
more
cover?
about that.
Or anything else you want me to know?
No, we chatted, I thought we had that discussion already for this ivory tower one that we've been.
Dude.
The professional standards, my
But we
understanding is.
But we
that-
don't have an agreement on that. do we?
Oh, okay. But it's argued.
Yes.
Okay, I'm sorry. No, I don't have anything more on that, Your Honor. Appreciate you're gonna consider it. I think we also talked about it. It might be somewhat fluid depending on how the evidence comes out. We would maybe have to address some things at the bench.
As they come up.
I mean, it's like anything. I
So
I could screw up and open the door, but
because we have an agreement on the state's motion in limine regarding Kacee Terry.
yeah. And on the other one, I think we were close enough to this question of.
Are we going to deal with that on just a case by case basis then on defendant's motion in limine regarding professional standards?
Oh, no, I think that my understanding is that we were pretty close except for to the question of whether any professional can have elicited the answer to the question of what a nurse would do, what a nurse should do, what I would do if I was a nurse. That sort of thing. The fact that she was is relevant.
Yeah, and I guess this just gets into the much larger and nuanced discussion surrounding causation, because the fact that she was a nurse, the knowledge that she did have about steps that she either affirmatively took or blocked from happening, that all is directly relevant to her knowledge as a nurse. And so the state would like clarification on, and as I said before, I think any prejudicial unduly, it's not unduly prejudicial under 403 because what we're talking about here is murder. I don't think the state or the jury is not going to be unduly prejudiced by also hearing that she may have violated nursing ethics. But not allowing the state to talk about what a nurse would have known or would have known would be medically appropriate at any given time. I think the state is fine to not ask its witnesses, what would you have done in this situation? But what would a nurse have known or been aware of that needed to happen or not happen in any given, that goes directly to part of the state's causation argument here. And so I think we do need to know the judge's position on that before we proceed.
And that was my understanding.
Okay, I missed that part. Yeah, I think that's too tricky. I think that it's making sort of increasing the duty in relation to rendering aid, which is not, it's not a crime to fail to do it. It's not a crime to fail to do it, whether you're a doctor or nurse or a busboy. And I also we will be taking this position that not, and so if that's the case, then not doing it that causes, right? No, don't really need to talk about around these issues. The evidence is going to be that Meggan Sundwall was present in some capacity, in some place, in some time where Kacee Terry was in a position that she may likely die. Ironically, this triggers this attempted suicide question again, as we're circling back, because failure to render aid wouldn't make her a murderer under any circumstance. She reasonably believed that Kacee Terry was attempting suicide. Why wouldn't that be an affirmative defense? So not doing something, omissions, acts of omissions, our position is the state can't argue that those meet the causation requirements for murder. We better figure that out if they're going to, because
Let me ask you this regarding the nursing standards. I can make a ruling that the state's prohibited from presenting any evidence as it relates to the defendant violating her professional standards. To say we're gonna have a doctor come in, and he's gonna be asked, "Hey, do these numbers make any sense to you?" And he's gonna say, "No, no one would be alive at that point in time." You would object to the question then, well, would a nurse know that? Is that what you would be objecting to? Would a nurse know that these numbers would mean someone wouldn't be alive? I mean, it's because I don't want to put such a fine point on it, but I need to know where we're coming from. And again, some of these are going to be case by case.
and that's sort of the answer, because when that context came up with the numbers and such, they were in past communications that had occurred where Kacee Terry is in text messaging giving vitals to Ms. Sundwall. And it was elicited from Dr. Masteller that that's ridiculous, right? And I got him to agree and point out that nobody who even knows anything about vitals would think that they could possibly be true, let alone a nurse, let alone a doctor.
So is it the second question you'd be objecting
Yeah.
to?
Yeah,
Then say,
especially a nurse,
what
because
if
now all of a sudden,
nurses know this?
yeah, now she gets this special duty, this special imprimatur that is only prejudicial, it's not probative. Now, moving to what the other question you asked, it's really not about those communications anyway. Those weren't the day of. Those had nothing to do. Those communications are historically about vitals. You may remember, by the way, that Kacee Terry was so obviously lying to Masteller sometimes about her glucose levels that he didn't even take them seriously or refer her to a hospital. He got a reading from her once that was 32 and he just ignored it. Why don't we get into all that? How about the day of? The day of, the evidence is that a glucometer analyzed Kacee Terry's blood throughout the day, her glucose levels in her blood, sorry. And the data indicated that she was descending to a point that she could die. And that measurements that supported that were taken at a time when Kacee Terry would have been unconscious, according to the data. In other words, someone else continued to measure the blood because Kacee Terry would have been unconscious. That doesn't why are any mention of or imprimatur or special position of that the person in the room was a nurse? All we did is we add this sort of veneer of duty that I submit is not relevant.
So is the state saying, I mean, is your position then, you want to ask that follow-up question, would a nurse
Absolutely.
know this?
Absolutely. And it is,
Not would Miss Sundwall know this, would a nurse know this?
would a nurse know this? Obviously, we can't say for certain what Ms. Sundwall knew, but would a trained licensed nurse know this information? And Mr. Williams made reference to the vitals that Kacee had been sending for years that were obviously implausible. And it goes back to the state's whole theory. And if we're talking, I mean, it kind of ends up looping everything in, because if aiding suicide is allowed to be instructed upon and the jury is allowed to consider it, they have to essentially find one of the elements of aiding suicide is that Ms. Sundwall had knowledge that Kacee intended to commit suicide. The fantastical nature of Kacee's lies to Ms. Sundwall and her going along with those as if those are real vitals and not, you know, saying, hey, I know you're lying. This is not, this is not believable. That all plays back into her knowledge. What was this, an actual suicide attempt? Was Kacee to be believed about any of these things? And the fact that she is a nurse is directly relevant to that, because she, you know, I have no experience with vitals. I would take a guess that some of the ones I'm looking at are not correct, but in terms of you know, how would somebody be functional? What would be happening to their brain capacity? Same with blood glucose levels. Like, it's going to be highly relevant at what stage, and whether the defendant would have known that and would have known whether it was a medical emergency. And I'm happy to not get into would professional nursing standards have required her to do something, and we're not going to be arguing anything to the effect of omission or failure to act. Everything we'll be arguing as part of causation, as part of proximate cause, as part of condition of peril, which are all legally admissible instructions to have on causation here. It would be affirmative steps that Ms. Sundwall took. But these affirmative steps that she took, the importance of them is highlighted by what she knew as a nurse, because a regular lay person may not have known that these steps would have the ultimate cause that they had. And her knowledge as a nurse goes to our entire theory. And I just don't think that the potential prejudicial effect outweighs the probative nature of that evidence.
Okay, I think I understand where everybody's coming from. I don't think it's going to be possible for me to make a blanket ruling on this before. I think we've got to handle it on a case by case basis, depending on the witness and depending on the question. And at that point in time, I'll have to consider the admissibility as it goes. That may happen a lot. It may not happen at all. I don't know. For that purpose, I'm going to hold off on making a blanket ruling. We're just going to have to deal with that as it comes up with each witness. And I'll have to consider the circumstances and where we're going. So I think we're clear on defendant's motion then. State's not going to present evidence that the defendant violated her professional standards as a nurse.
We won't couch it that way.
Okay. And then if you do, I know there will be an objection and we'll deal with it. And then as it relates to any other, or the admissibility to other evidence offered for other purposes as it relates to a nurse, we're just going to have to consider that at the bench as it comes up. So I don't need to take that under advisement. I think it's impossible to make a blanket ruling on that, on these types of issues for purposes of trial. We'll handle them as they go. Okay, so for purposes of this case and what the attorneys are looking for, you need a response from me as it relates to the memorandum and the interplay between murder and aiding suicide, just so you both have a direction of where we're going.
And to formulate your instructions.
Okay. And you guys have been working on jury instructions already. We have an agreement as it relates to preliminary instructions. We have stipulated preliminary instructions.
Correct.
Ms. Thomas.
Judge, this was not queued up as part of what we were going to address today, but it is something that will occur, that will come up with the first two witnesses. And it has to do with the prior ruling that Your Honor made with regard to evidence of the decedent stealing from her grandparents. As I understood your ruling on that, it was subject to admissible proof of that happening before that could be referred to by the defense. Is that a fair summary of your?
I don't have the ruling in front of me, and I haven't reviewed it this week, so.
What I wanted to bring to Your Honor's attention, because like I said, it's going to come up in the first two witnesses. Once that word comes out of Mr. Williams' mouth, stealing, it becomes it's a loaded question, or it's loaded for the jury. That implies something that in the state's view is simply not true. And your indication previously that it would have to be admissible evidence, there is none that she was in fact stealing. There is no proof of identity. It could have been anybody in the household that was using the credit cards that she's being accused of having used. It's easy to blame it on the dead girl. There are no videos of her using it. There's no receipts with her signature. There's no indication from her devices that she was ordering items for her own use and using those credit cards. There is simply no proof. And in fact, she was never even interviewed, because this only came to the attention of anybody 2 months after she died. And again, like I said, at that point, it's easy to blame the dead girl. In addition, there is no proof that it would rise to the level of being able to be called a theft, because there is an inability of one of the victims involved, one of the grandparents, has dementia, and so could not provide reliable, credible evidence as to whether the whoever used the card had authorization to do so. So calling this a theft is simply inaccurate, unfair, and is not supported by the reliable type of evidence that this court indicated would be necessary in order to go under that theory.
And thank you. I'm looking at my ruling now. And I said the evidence of Ms. Terry's alleged theft from her grandparents must not be overly extensive or a significant focus of the defendant's case. To facilitate this order, defendant must proffer in a Rule 104 hearing outside of the jury what evidence she intends to offer. And then the defendant is precluded from arguing to the jury that the evidence of Ms. Terry's alleged theft shows bad or dishonest character. Instead, defendant must limit all arguments based on this evidence to Ms. Terry's motive to take her own life. So I guess it's kind of going to depend on where the defense is coming from at that time.
Yeah, I'm actually glad this was raised, and maybe we should have thought to. I'm a little surprised in the context, Judge. The theory of the case agents in this case repeatedly indicated on tape to Mark Farnsworth and others. The theory of the investigating agents is that Kacee Terry engaged in fraud, engaged in theft, engaged in laundering it for drug activity to one of the witnesses who's going to be coming up, that the investigators here worked through. Then we did provide you materials with the motion that an agency concluded that occurred. Then we provided a section of the police report where Farney concluded that occurred. Mark Farnsworth explains at one point to the police later that the bank agreed and reimbursed it. Now, to try to split hairs as to whether we can prove it was Kacee Terry I would absolutely tell her she had to do a plea bargain if this was the evidence against her. It just is overwhelmingly circumstantially proven that it's her. Everyone believed it. The case agents here believed it. And now there's been a new development, in fact. And I want to be gentle about this, but this motion that was brought by the state on this subject argued that since there was no knowledge by Kacee Terry that she might be under the gun, that she might be discovered, it shouldn't be allowed. And we won the motion, so we didn't go any farther. But then we've later learned, and I'll take responsibility for not knowing the evidence well enough by the time we did that motion, but that's going to have to be the state's same defense, because it turns out Mark Farnsworth, within days, is on the phone telling these agents she knew there was a confrontation in the kitchen. And get this, Mark Farnsworth says that might have been why she committed suicide. And he says it again in another interview. And he has told them again in a trial prep interview that not only did Kacee know that it was in the kitchen where he was saying, we're going to start looking at these bank statements. Kacee canceled the card for your grandma. And Mark forms the opinion and belief that that coming to light could be a reason that Kacee committed suicide, directly related. So it is absolutely going to be a major portion of our case to deny that she might have been. I've told you about in the argument. She built this house of cards. She's dealing drugs.
I know the facts.
Well, but it's the roof's coming down. That has to be relevant to whether or not whether she'd been faking it for years, was actually going to do it this time.
Ms. Thomas?
Judge, I don't want to beat a dead horse here, but if Mr. Williams' position is that because an investigator concluded that it happened, then we wouldn't have the need of criminal trials. And that's just simply, obviously, constitutionally not the case. Like I said, in this particular case, he says he would have urged a plea bargain. I would never have charged it because there was no proof that she was the one that had used this card, and there was absolutely no proof that it was used without authorization. You mentioned that he would have to do a 104 hearing. That would have to take place before the first two witnesses testify, because one of those is Mark Farnsworth. Mr. Williams has also misstated what Mr. Farnsworth would say, which is not that this is the reason she committed suicide. What he would say is, this could have been a reason that she may have considered suicide. Those are vastly different things.
Won't a lot of this come out then anyway on direct and cross?
But it's already rung that bell for the jury, Judge. And it's not true, and it's not fair to create that inference for the jury that is simply not credible. And this wasn't part of our original argument, primarily because your ruling specified that it would have to be admissible evidence that would be used in order to allow this evidence to come forth. The alternative agency that Mr. Williams just referenced is APS, who did not conclude that it happened. They closed it because they were unable to continue the investigation because Kacee Terry was dead. They also were considering whether those misappropriation of funds was perhaps done by Kacee's aunt, not Kacee. And in fact, as my recollection is that the bulk of the amount that he kept referencing during the preliminary hearing as tens of thousands of dollars were more attributable to the aunt than to Kacee. So again, there is no reliable proof that Kacee was taking these funds from her parents, or her grandparents, sorry, without authorization. And for that reason, we are asking that be prohibited because of the lack of credible evidence that it occurred. And in doing this, Judge, and this is a sensitive topic, and I'm not meaning to be accusing Mr. Williams of misconduct in any regard, but his characterization of what Mr. Farnsworth's testimony would be is endemic in the questions that he asks his witnesses as well. And I wanted to get a direction to Mr. Williams about his questions to witnesses, because he raises words like this that are loaded words. He calls her, he accused her of stealing when that's not the case. He accuses her of being a drug dealer when that's not the case. He accused her of being an addict when that is not the case. And he throws those words out, and they have meaning for a jury that are, that you can't unring that bell. And his use of those words is not appropriate in conducting examination of witnesses. In addition to that, he has a tendency to misstate the evidence in his questions. He did it with you today, Judge, when he said that that Ms. Sundwall had done a search on what glucometer readings mean, when in fact the actual search was how low does a glucometer go? Those are vastly different things. And I understand, I don't think he's intentionally trying to mislead anybody, but that he throws out these things that sound like they're factual and they're not. And that it misleads the jury as to what the actual evidence is. Another tendency that he has is to ask a question, and the witness evidences confusion or misunderstanding. He says, well, we'll show you that later or something. And then of course never does. And that again applies that there is evidence of something that he's claiming that isn't there. And I wanted to cue this up for your honor, because it is a problem I see in the way that Mr. Williams deals with witnesses that is frankly unfair to the witnesses.
Thank you. I don't need to make a ruling, an additional ruling as it relates to that today. We can deal with it on a case-by-case basis if it comes up. I've already ruled that the evidence of Miss Terry's alleged theft from her grandparents must not be overly extensive or a significant focus of the defendant's case, specifically because there's a danger of unfair prejudice. These cases are extremely difficult, and every lawyer is going to approach it different, and not every lawyer is going to like how each lawyer approaches it. It's my job to make sure that the rules are followed and that the jury gets the evidence that they're entitled to see. Everybody's going to have differing opinions on how style affects jury's opinion, certain attorneys and things like that. We're going to get there. I'm not going to make a ruling on that today. I don't think I need to. I've already ruled on the motion. Parties are already aware of what's intended. It's just not to be an extensive or significant focus of defendant's case. The issue is going to come up, and we'll deal with it.
Yeah, I think that the importance, and Judge, I'm happy to put together a full packet with all the investigators saying that Kacee Terry was stealing, that she was doing it through Venmo accounts so she could get it to her drug dealing activities. I'm astonished that the state's taking this position. I'm happy to, if you want it ahead of time, but so you can see that it's a justified area beyond what we might have even anticipated when the motion is. I guess we'll go to the trouble of putting it. I have it queued up right here where Mark Farnsworth says that within 4 days of this event on a phone call to the detective that she was stealing, she was confronted with it, and we think that might have been a reason to commit suicide.
Whatever you intend on giving to the court, obviously you got to give to the state.
Oh, no, I would put
So
together
so they're aware of it.
a packet. I just thought I'm surprised to hear we're going back to proof about whether it happened, because it's gotten stronger since we got the motion.
And I've made my ruling on the motion. I think parties are aware of what's going to be required. Anything else we need to cover?
I don't think so. We can talk about that. I gave you, I filed our, I mean, yeah, we can give you. Sure.
We'll do what we're obligated to do.
What I was meaning to discuss some practical things, Your Honor. First of all, could the court remind me, we're doing only jury selection on Tuesday and then starting openings on Wednesday morning?
That's what I anticipate.
Okay, that's what I thought.
Yeah, so
I
you'll
thought
all
so.
have time.
We're asking that the state provide the defense with the anticipated order of witnesses for the trial.
Do we have an agreement on that?
Yeah, the state's happy to do that. We filed an amended witness list, I believe, late last week or earlier this week. We had pared it down from what we had originally filed. I don't know that it's in the order that we've landed on, and that still may be subject to change just based on pacing and scheduling of different witnesses. But we're happy to give the order that we intend right now to Mr. Williams.
I think that's just helpful to everybody. I always ask attorneys to keep the lines of communication open. These trials are fluid, a lot of things. There's sometimes a lot of fits and starts, and anything you can do to smooth the process out better. Helpful. Nobody's hiding the ball from anybody. All right. Anything else, counsel?
I don't believe so.
Okay, so we're gonna meet counsel. Jury's gonna be here at 8. I usually meet with counsel back in chambers at around 8:15, just to go over any last minute things. It takes just a couple of minutes. So the morning of jury selection, we'll meet in chambers just to go over any last minute additions. Oh, the one thing I wanted to ask all attorneys. If there's any specific questions, I'm working on my trial outline right now and I've got most of it done. If there's any specific questions related to this case that aren't in the questionnaire, question or questions that you want asked to the body, by the raise of hands, where everybody can just raise their hand, yes or no, I'm happy to consider those questions. So if you have those and want to get them to Brooke, and I'll review them and then I'll make a decision whether I think it's going to be needed or not. I don't intend on asking 7, 8, or 9 questions to the body, but if I usually do 1 or 2 that's case specific, that I found to be helpful. We don't have to do any. But if either of you think it is, talk with each other and see, and then let Brooke know, and I'm happy to include that.
Again, procedurally, you'll do general voir dire, talk to the body, do you groups of 20?
Here's what we'll do. So we've got 60. Well, I'll tell you right now, I think I've probably excused a dozen witnesses already, or a dozen jurors already, just based upon conflict and scheduling and everything, and they're all for good cause. There may be more than that. We may have a handful of no-shows too. We're scheduled for 60 in the morning.
60 in the morning.
And then 60 at 1 o'clock.
Oh.
And so what we do is I come out, I give my opening speech, I talk about the length of the trial, read the information to them, go through the qualifying questions, you introduce yourselves, you talk about witnesses. I ask a couple of other questions where they can raise their hands, and then we go right back into chambers and start one at a time in voir dire and just work through them.
Great. Yeah, thank you.
Judge, do we have the jury questionnaires and can we get those?
I'm gonna email that out right now.
Great, thank
Great.
you.
Thank you.
So you'll get those. You may not know. Will they know who has been excused and who hasn't before? We won't know before. Is there a way to get that?
It's closer and I can email.
Okay.
The list of who's been excused when I get that.
Okay, so as soon as we know the master list of who's been excused, you'll get that too. And I'll go through that with you guys anyway.
That'd be very helpful. So obviously we'll have to review their jury question.
Yeah, and hopefully we'll have that before Monday, I
Well,
hope.
The second point was, how do you like to handle for causes that are stipulated? In the past, I've gotten with counsel, and wherever we had an agreement on a for-cause challenge, we listed the joint for-cause challenges and gave them to the court ahead of time.
That's up to you guys. However you want to handle that. We'll be back in chambers. If there's a witness that you guys don't want to question, great. If there's a witness that you both have an issue with before they come back and someone wants to challenge, we'll talk about it. The key is just to keep it moving.
Right.
That
We don't
get
don't
bogged
need
down.
to be talking to someone that we're both going to move to strike for cause.
Yeah, just if that's the case, it usually becomes pretty clear.
Okay.
During the process, you'll figure I know every judge does it different, and you've all tried cases in front of a ton of different judges. And no one judge is the same, and I'll be different on the way I do selection too. But we'll get into a rhythm and we'll work through it.
Thank you, Your Honor.
My goodness, I know what effort goes into these cases, and I want to thank everybody involved. Anything else we need to cover?
I don't think today. Thank you, Judge.
No, thank you, Your Honor.
All right. I appreciate everybody's efforts. Ms. Sundwall, stay in contact with your attorney. We'll see everybody. You'll be hearing from us before then, most likely, on the issue that is outstanding, and we'll see everybody on Tuesday morning.
Thank you, Judge.
Thank you.
Thank you, Your Honor.